In this session, we'll talk about structure of the Patents Act 1970, which is very important, especially when you are writing the Indian Patent Agent exam. So this is the Patents Act 1970. I usually buy the Dare Act from Universal Publications, and this act is called as the Patents Act 1970, and the short form of this act is a just Act, which came into force on 20th April 1972. And before this act, we had the Indian Patent and Design Act 1911. And you see reference of this act given in a couple of places in the present act. After enactment of the Patents Act 1970, the act was amended in 1970, then 1999, 2002, 2005, 2021 and 2023. You can just make note of these enactments. Maybe you get some question in your exam. In 2005, a major amendment was done when India signed TRIPS agreement, trade-related aspects of intellectual property rights, and then patent protection was extended to product patents, including pharmaceutical drugs. Before 2005, we had only process patents in the country, but after India became compliant to TRIPS agreement, we started granting patents on products as well as the process. The patent rules have been amended much more frequently in 2005, 2006, 2012, then 2013, 14, 16, 17, 19, 2020, 21, and 24. But these amendments are made only in the rules. So when amendments are made in the rules, it is mostly change in the forms or change in the fees. Okay, and I will explain to you what is difference between the section and the rules. This act has total 23 chapters, 162 sections, 138 rules, and 5 schedules. So this is overall structure of Indian Patents Act 1970. We have 5 schedules in Patents Act. First schedule refers to the fees which is to be paid, for example, fees for filing, fees for requesting examination. Second schedule refers to the list of forms which can be used for various purposes. For example, the form to request for examination is Form 18 and so on. Third schedule is form of patent. Fourth schedule is a list of matter in respect of which cost is to be awarded. And fifth schedule is related to rules 19 to 19A, 1B, 19B, 5, 19B, 12, 19H, 19K5, and ISA fees, in International Search Authority fees. So this fees is applicable when PCT with respect to PCT, and we'll talk about in detail in PCT session. Getting started with the Patents Act 1970. This act has sections. So sections primarily tell you what to do, okay? And then rules, they support the sections. So rule explain how to do. For example, section 11B explains about the examination of patent application. So section says that examination has to happen. You have to request for examination. But Rule 24B of Indian Patents Rule 2003 explains that Form 18 has to be used, what is the fees, and how the form should be filled. So, sections tell you what is to be done under this act, and rules explain to you how it is to be done. The Patent Act's 1970 is title of this act. Okay, so there is a name of every enactment. So this act is called as the Patents Act 1970. You must read the preamble also. Preamble explains why the law was enacted and its objective. You must understand structure of the act. We have chapters. 23 chapters are there in this act. We have sections. Every section, most of the sections, they have subsections also. And in some sections, there is explanation given about the section. And then we have rules, and then we have schedules. Before starting to read the Patents Act 1970, Section 1, if you read Section 1 and Section 2, they talk about the definition. and all important terms which are used in the act, they have been defined. So if any term is defined in the act, so this will have meaning only with respect to the definition which is given in chapter 1: person, controller, patent, and inventor. So you must go through all the definitions which have been given in chapter 1. Read one section at a time. Understand what a chapter is all about and the logic behind it. If there is a chapter on compulsory license, first of all, read about compulsory license and find out why we have compulsory license in place. Was it there right from the beginning, or was it introduced later on? So understand gist of that chapter, what that chapter wants to talk about, and then go through the sections one by one. For each section, read the heading, because every section also has a heading, okay, like section 84, section 85. So read the title, understand gist of that section. So first of all, you understood gist of the chapter, then you understand gist of that particular section, and after you understand the gist, then you move on to the details and read through the subsection. Understand the section as a part of specific chapter. Break down long sentences. You all come from science background, and for you it might be difficult to read the legal language and understand it correctly, and it may be very tricky, subject to interpretation, and confusing at times. And in some of the sections you see that there is a big paragraph, and if you read through that paragraph, you find that the entire paragraph is just one sentence. Legal provisions usually contain conditions, exceptions, time limits, procedures, and you must rewrite them as bullet points. For example, instead of reading, a patent may be revoked if there is a long section, break down into smaller sections. A patent may be revoked when there is lack of novelty, lack of obviousness, insufficient disclosure, wrongful obtaining. So if you break your sentence into smaller sections, then it will be easy for you to understand that section. And repeatedly, I'm telling you that, uh, you know, understand gist of that section first of all. Look for keywords. Now, if in the act word revocation has been used, then you cannot use the word synonym of revocation. So, in legal language, sticking to keywords is extremely important. If the word in section 64 is revocation, you have to use the word revocation. You cannot use the word cancellation, invalidation. So, and if the word opposition has been used in some sections, then opposition means just opposition. Restoration, revocation, lapse, expired patent, patent application, grantee, proprietor, patent holder. So where the term has been used specifically as lapse of the patent, you cannot replace it with any synonym like expired patent or something. Look for the keywords in this in all the sections also. Shall means mandatory, may means discriminatory, must, unless, notwithstanding, subject to, provided that, except, deemed, includes, means. Understanding these words changes the meaning of the section significantly. And just pay attention to the keywords which you are using in the act. Read the proviso carefully. The proviso usually creates an exception. For example, the controller shall grant the patent provided that the applicant complies with the requirements. So main rule is that patent shall be granted, and the exception here is only if the requirements are met. Cross-reference other sections. Statutes often refer to other provisions, like subject to section 64, this section says so and so. So you must know section 64, because there is a lot of cross linking happens. If examiner, if a particular section refers to the examination process, then better you go through that section first, and then come to the advanced section. So cross linking, if is done, or cross reference is done, then you have to understand all the sections which have been referred there as a cross reference. Read the rules alongside the act. So as I told you, that act tells you what to do and rule tells you how to do. So you have to map rules and sections. So you have few chapters on section, few chapters on rule, and they come one after the other. But while reading the section, you must go through the rule which relates to that particular section, map it, and then holistically read through the section. The act gives the legal framework, and the rules explain forms, timeline, fees, procedure. For example, Patents Act 1970, Patent Rules 2003, both of them, they should be read together. Read important case laws, because a lot of terms have been interpreted by the courts in case laws. So you get clarity on sections after you read the case laws, and there are some very significant case laws in the past. For example, Novartis case for Section 3D, then patentability of microorganisms. You have Anand Chakravarti and versus Diamond case. So if you read through case laws, you will understand the sections better. Courts explain how statutory provisions should be interpreted. After reading a section, find the leading judgments, note how courts have been interpreting the ambiguous terms, and reading through the recent case laws will also be very helpful for you to answer the questions in Viva. Make your own notes. For every section, summarize what is the purpose, condition, exceptions, procedure, penalties, or relevant case laws. You can also write down if there is a relevant form, fees applicable. And if you make your own notes, then it will be certainly be very helpful at the time of your revision. Instead of reading the entire section at once, read the heading first of all. Just to give you one example, if heading of uh, the chapter is what are not inventions, find out why we have this section, why do we have this chapter at all in the act, what is the need to have the list of inventions which cannot be patented, and then you go to the subsections, read the clauses like section 3D. Section 3D is one of the most controversial sections of Indian Patents Act. So find out why it was excluded and what are the exceptions. Is there a case law to prove any term specifically to this section? So there was a term efficacy, which was interpreted in Novartis case, and this term now is integral part of Section 3D. Write a one-line summary of the section or subsection in your own words, and that will be helpful for you before your exam. General tips: read slowly again and again. Multiple revisions are very important. In one shot, if you feel that you will read this Patent Act 3 times and you will get hold on it, you are mistaken. You have to read it again and again, and you will be surprised that every time you will understand Patent Act differently. Read slowly, because legal language is very precise. Because in science, if you replace the keywords, it doesn't matter much as long as you are conveying the meaning. But in legal language, you have to stick to the keyword. I don't say that you stick to the same language which is given in the Bear Act, because that language is very loopy language, and it is tricky. But stick to the keywords. Highlight the defined terms. Keep the act and rules open together, because you must map rules and sections to understand everything about that section. Refer to judicial decisions for interpretation. Create flow charts and summaries for complicated provisions. And flow charts are really helpful if you make flow charts, because visual is always more impactful. Read the chapter headings, read the definitions that apply, read one section at a time, and then move on to the next section, because in one chapter you will see that all sections are interconnected. If you have not read the initial sections and you have moved on to the advanced ones, then you will not understand anything from that chapter. Simplify the section into plain English. Read the corresponding patent rules, and when you're simplifying the sections into plain English, make sure that the meaning of that particular section is not changed and the keywords are kept intact. Study the leading court decisions on that section. Review practical examples on how the provision is applied. This method helps build both a clear understanding of the law's text and how it operates in practice. Golden rules to interpret a statute. It is a very interesting subject, and this is one of the full-fledged subjects which is taught to the law students, that how you should understand a statute. So there are some rules which have been given. Statutory words should be given their ordinary and natural meaning unless doing so would lead to an absurd, uh, unreasonable, and unjust result. In such cases, the court may modify the meaning only as much as necessary to avoid the absurdity, while preserving the legislator's intent. So, statute should be understood in its plain and simple, reasonable meaning, and you cannot play tricks around that language. There was one example my professor used to give in the class when I was doing law. Father gives credit card to his son and says that you buy tomatoes and potatoes. Okay. And son goes to the market, he buys potatoes, tomatoes, but he also buys a bike. So was it a ordinary interpretation or it was a clever interpretation? And when father asked son, he said, you told me what you buy, whatever you want to do, you want to buy. Now what father meant was like, you can buy tomatoes and potatoes and whatever you want to buy from the vegetable shop, right? Father never said that you buy bike. But if you have to be if you have to interpret the sentence in a wrong way, then you can buy jewelry, you can buy a bike from the father's credit card. Suppose a law states that no person shall park a vehicle in the park. uh, Literal interpretation is that even the ambulance cannot be parked, because the law says that you cannot park any vehicle. But golden rule of interpretation says that the court may interpret the provisions to allow emergency vehicles, because a literal reading would produce an unreasonable result. So literal meaning is also not good. Smart interpretation is also not good, and you should not have any mischievous interpretation of the statute. The golden rule allows a court to depart from the literal meaning of statutory words only to the extent necessary to avoid an absurd, unreasonable, or unjust result while preserving the legislator's intent. That's why understanding the intent of that chapter is important, then slowly move on to the section. And once you have done one full reading of the section, in the second round, map rules with it. That's how you understand, a particular provision of this act properly. There are two questions I could find which everyone asks during patent agent examination. Should one remember all sections and rules for the exam? No. You must remember important sections, definitely. Section 48 is important, section 84, 90, 92, they are important. What happens is, suppose you have one question on export of pharmaceutical, uh, compulsory license related to export of pharmaceutical compounds. Okay. Now, if you are answering that question, option one is that you state we start that you need compulsory license to export pharmaceutical compounds to a foreign country. Now, option two is when you are referring to the section according to section 92A of the Patents Act 1970, following are the provisions. Examiner will give you extra marks if you have referred to the section, because examiner now knows that you know the section correctly. Okay. But here, instead of writing the wrong section, if you don't remember it correctly, you can skip it, but at least try to remember the important sections. And rules, I think it is fine if you don't mention rules, it's perfectly all right. And if there is a question on for example, if there is a question on uh, what is the process to file patent application in India, then you must refer to the rules, and you must write down what is the right form and the right fees to submit the application in India. But rule you can still skip, but it is important to mention the section. And that's why it is important to make note of important sections so that you can refer them during your exam. I remember I wrote my patent agent exam in the year 2006, and I had printed index of the Indian Patents Act. It was some 6 7 pages, wherein it was index of like chapter one, then whatever sections are there, and then the heading of those sections. So I used to keep a printed copy of index on my dining table. So while traveling, when I'm in auto or in a bus, I used to keep that handy, and one or two sections I used to remember, learn every day. So that's where you can have some coding if you want to have, but do remember important sections. Second, most frequently asked question is, should the same language be used in the question in the exam as given in that? No, you cannot actually remember the section, the same language which is given in the act. You can write answer in your own language, but as I repeatedly said that stick to the important keywords. Revocation means only revocation, lapse, restoration, compulsory license. uh, Use the keywords as such, and otherwise you can write the answers in your own language. There is no problem, absolutely. Thank you very much for attending this session today. I hope you enjoyed it. Stay tuned for more videos. All the best.